updated. All right, so welcome back. We are picking up our work here in House Affairs. Picking up our work on H-125, our boards and commissions bill. So Tim, why don't we take a look at the latest and greatest amendment here? Could you tell me which, because we have a number of different documents under your name just for the committee, which file that is?
Yes, this should be, let's see, draft 2.1 of the amendment. Actually, let me pull up the committee page. I'm not sure exactly what it says it's under.
It is the last
2.1 or the bottom one.
Right.
Wait, there's more than one 2.1?
Yeah, there's one.
There's one that's a summary.
Yes, it looks like
Yes. Because I got 5 or 6 page summary.
Yeah, so
It's got a 10 a.m. timestamp.
yeah, so to orient the committee, the 10 a.m. timestamp. So this is, we have this big 140 page bill. This amendment that we're going to walk through first incorporates the 3 instances of amendment that we were talking about to add to the bill. So Tim, would you walk us through the amendment and then we'll take a stroll through the.
Yes, absolutely. For the record, my name is Tim Devlin, Legislative Counsel. The amendment you have before you is, again, draft number 2.1, time-stamped for today, March 16th, 10 a.m. The first instance of amendment should look familiar. This is not changed. This is about the creation of a summer government accountability committee. And this simply adds a new section 2A. And this amendment runs through page 3. The second and third instance of amendments can be found on page 3 going to page 4. The second instance of amendment will modify section 101, which will amend Title 18 VSA section 4201 by striking out subsection 45 in its entirety and inserting in lieu thereof a new section 45 to read as follows. Subsection 45, benchmark unlawful dosage means a maximum recommended therapeutic dose or maximum daily dose as determined by the department by rule. The third instance of amendment, starting on line 19, in section 140, effective dates, by striking out and section 137, amending Title 30 VSA 8015, shall take effect on June 30th, 2025, and inserting in lieu thereof, and section 137, amending 30 VSA 8015, shall take effect on June 30th, 2027. So that the latter, that is the third instance of amendment, just pushes out that sunset date for the Energy Commission by 2 years.
Any questions on the amendment language? Tim, I think that means you did a fabulous job.
To approve this.
So that I was just conferring with our committee assistant. I think that what we'll do is take one recorded action. I think we can take one recorded action that encapsulates the bill with these instances of amendment. You're reading my mind, Representative Mrowicki, because we've mostly done to date strike calls, right? So I need to make sure we're doing the right order of operations here, since we have these instances of amendment to the underlying bill. So any questions about the amendment itself before we move on to the bill? So Tim, I just wanted to make sure we can do a jog through the bill itself.
Sure.
So we'd be looking at the bill as introduced, correct?
Yes. And that should be, let's see, under my name on the committee page, should be the third document. H-125 is introduced, boards and commission. I also think it'd be helpful for committee members to pull up the summary, which is the second document, which I've updated to include page number references as well as links to informational materials that were submitted to the Sunset Advisory Commission as well. And would it be helpful if, Chair McCarthy, if I actually just perhaps go through the summary?
Yeah.
Okay.
I think the summary would be great. And then if you can refer to those three instances of amendment where they are in the bill, just to orient the committee so folks are.
Absolutely. So, sorry, and this summary is dated 2.1. There was a previous summary, as I just indicated. However, well, we'll just jump into it here. This bill serves as a vehicle for the Sunset Advisory Commission's 2023 recommendations. As currently written, this bill will either repeal or prospectively repeal 11 different boards and commissions and will amend one commission's provisions. The bill sections are organized by title order. 120 pages of the 140 pages total pertain to the repeal of two boards. One, the Board of Health, and two, the Board of Gas and Oil Resources, the Natural Gas and Oil Resources Board. The first part of the bill pertains to Government Accountability Committee. There's two sections. Section 1 repeals the existing Government Accountability Committee, and Section 2 inserts an intent provision. This is where we'll find the first instance of amendment, which will create the Summertime Government Accountability Commission. I'll pause there for a moment.
We're good.
Okay.
Representative Higley?
Yeah, Tim, just when that is inserted, it's not going to be inserted as an amendment per se. It's just going to be included, correct?
The Summertime, the language for the Summertime Committee will be inserted as a, right. It exists an amendment, it will add a Section 2A. So it won't really throw off the order of anything subsequent to that.
Okay, thank you.
But it will appear in the calendar as so there'll be the bill as introduced, and then there'll be the instances of amendment as recommended by our committee.
Okay,
If we adopt the amendment as well.
okay.
We did not set this up as a strike call since it was such a big bill and. All right. Okay.
The next part of the bill pertains to state boards and commissions registry. This will amend Title 3 VSA, Section 116A, the State Boards and Commissions Registry. The revisions that were provided from Director Tanya Marshall, the State Archivist and Chief Records Officer, really will have the effect of reducing the number of items to be tracked by the state archivists. I believe it was removing references to certain federal entities. I'll pause there.
I think we're good there.
The next part of the bill pertains to the Vermont Pension Investment Commission. This language in Section 4 can be found on page 2. This will amend 3 VSA Section 522, that is the Vermont Pension Investment Commission, to make the commission more independent from the Treasurer's Office. The next part of the bill, pertaining to the repeal of Agricultural Finance Program Advisory Panel, can be found in Section 5, in particular page 4 of the overall bill. This will amend Title 10 VSA Section 213 and simply be a repeal of the panel.
Tim, 203 or 213?
Oh, sorry. 213. The next part of the bill pertains to repeals of the Coalition for Healthy Activity, Motivation, and Prevention Programs, or CHAMPS, as well as the Fit and Healthy Advisory Committee. Section 6 can be found on page 5, and this simply repeals both of those boards. Or sorry, the coalition and the council. next section pertains to the repeal of the Birth Information Network Advisory Committee. This can be found in section 7, which is on page 5 of the bill. This will amend Title 18 VSA, Chapter 20, by simply repealing it. The next part of the bill pertains to the repeal of the Board of Health and its conforming revisions that will accompany it. This is the first large portion of the bill, one of two boards that consist of 120 pages total of the 140 pages of the bill. Sections 8 through 131 relate to the repeal of the board and removing references to it, and transitioning its authority to either the Commissioner of Health or the Department of Health. It's to be found beginning on page 6. And one note I have, I just like to point out that the transfer of rulemaking authority is in sections 131, found on page 81. And let's see, section 117, amending 18 VSA 4234, shall take effect on July 2nd, 2023, because there's a pending amendment to the language that will become effective on July 1st, 2023. This is also where we will find our second instance of amendment pertaining to those guidelines. Or sorry, benchmarks.
So that's top of page 64.
Yes.
Right, so the, right, okay.
Okay. The next section, or sorry, part of the bill pertains to prospective repeal of Nuclear Decommissioning Citizens Advisory Panel. Section 132 can be found on page 82, and this will put in a prospective repeal date or a sunset date to be January 1st, 2030. The next portion of the bill pertains to the repeal of the Vermont Prescription Drug Advisory Council. This is in section 133, found on page 82. This is a simple repeal of that council. The next part of the bill pertains to the Vermont Employment Security Board. Section 134 will amend title, and this is on page 82. Section 134 will amend Title 21, VSA Section 1302, and this will adjust the membership of that board. The next part of the bill is the second large portion of the bill. This runs approximately 44 pages and pertains to the repeal of the Natural Gas and Oil Resources Board and its statutory framework. Section 135 will amend Title 29, VSA Chapter 14. Again, this begins on page 83 and runs through page 127. This will repeal all but the prohibition of hydraulic fracking in the state in section 571, which is on page 127. And yes.
So I just wanted to, since the Natural Gas and Oil Resources Board, we did invite folks from ANR, but there was kind of a scheduling thing. I just wanted to direct the committee. If you look back at line 103 of the big chart, so that has our notes from the Sunset Advisory Commission, and you can go back and read some of the memos and stuff if you really want to delve into this. But I think the pertinent thing here about the Natural Gas and Oil Resources Board is the Sunset Advisory Commission reviewed it on December 16th, 2021. The Advisory Commission's memo from that date sent to the House and Senate committees on Gov.Ops and Natural Resources requesting committees of jurisdiction review this board for possible repeal. And then the questionnaire returned by ANR indicated that the board is defunct. The committee consensus was to repeal on September 21st, 2022. So it sounds like everybody last year was kind of on board that this Natural Gas and Oil Resources Board hasn't been meeting for a long time. Let's keep going.
Okay. The next part of the bill pertains to the repeal of the Review Board on Retail Sales. Section 136 can be found on page 128. It is a simple repeal of the board. The next part of the bill pertains to the prospective repeal of the Clean Energy Development Board. Section 137 can be found on page 128, and this is the third instance of amendment, where the effective dates will be updated so that instead of sunsetting on 2025, it'll now be 2027, I believe. Double check that. Excuse me. The next part of the bill pertains to the repeal of Vermont Telecommunications Authority. Section 138 can be found on page 137 and is a simple repeal. The next part of the bill pertains to the repeal and transfer of duties of the Private Activity Bond Advisory Committee. Section 139 will amend Title 32 VSA, Section 994, and the authority will be transferred to the Treasurer in coordination with the Secretary of Administration, the Secretary of Commerce and Community Development, and any bond issuing authority of the state or instrumentality of the state that is eligible to issue private activity bonds.
This is one of those consolidation. Is that John? And
the last part of the bill pertains to effective dates. And that is section 140, found on page 140, funny enough. And again, this the third instance of amendment will adjust that in regard to the Clean Energy Development Board's sunset date.
Okay. Any further questions from the committee before we take any action? Representative Wiki.
Are you looking for a motion?
I would. I think the motion should encapsulate the instances of amendment and the underlying bill.
May I speak to the underlying bill?
You may.
Yes, I suggest that we approve. Tim, what's the bill number in front of you?
125.
Bill 125 and the amendment to that?
And the amendment is draft 2.1
2.1
with a timestamp of 10 a.m.
10 a.m.
Thank you very much, Representative Murwicki. Any further discussion? Not the shall commence to call the roll.
Representative Barrow,
Yes.
Representative Boyden, yes. Representative Hingham,
Yes.
Representative Morgan,
Yes.
Representative Hooper Burlington,
Yes.
Representative Markey,
Yes.
Representative Chase,
Yes.
Representative Waters Evans,
Yes.
Representative Hooper Randall,
Yes.
Representative Nugent, Representative Higley,
Yes.
Representative McCarthy,
Yes.
11-0-1.
Committee, thank you so much for the good work on this bill. I think we've set in process a conversation that is going to lead for more work for us to do next year, and for, I'm sure, at least one or two of us from here to do over the summer. But I think it's really important that we keep going with this work, that we're efficient in making sure that our boards and councils and commissions, that they're not just out there as zombies, and also that the ones that we have doing really good work, that we look at the equity, the compensation, the ability to potentially consolidate. So we've just started on our work on this, but I think this is a good first step. Representative Murwicki has graciously agreed to be the reporter of this bill. I appreciate that.
We'll read all 140 pages.
Studiously this weekend.
So thank you very much, Mike, for the.
And to that end, Mr. Chair, I have a quick meeting I need to go to right now, but I'll be back soon. And I told Tim, it's nothing he said, I'm not walking out on.
Take offense.
Me give him a complex. It's already there.
It's well developed.
Still paying back.
Great, so I think, we know, right? Ben's gonna be here 11? Okay, great. So we have just a couple of. So committee, just as we're switching gears and waiting on folks, I'll let Tim go for now. I think you'll be back with us after the floor.
Yes.
But we're gonna rely on your colleague Ben for the next conversation. So thank you for all your work this morning, Tim.
You're very welcome. Take care, everybody.
So we have, just for context setting, this afternoon, we're gonna hear the latest draft, and I think there's consensus about recommendations of the Domestic Violence Fatality Review Commission. I think that we have everybody on board with a compromise proposal that we'll see this afternoon on that. That's kind of item number one in our bucket of things related to Criminal Justice Council law enforcement policy. Item number two, we'll really be discussing tomorrow in depth, which is the Criminal Justice Council recommendations that we had moving toward competency versus number of hours, that package of proposals that had come from the Criminal Justice Council. That works really for tomorrow. A related piece of that that's in the same wheelhouse, I had introduced to you all H251, which Chair Lalonde and I had done a little bit of work on. So if you'll remember a couple or 3 weeks back, we had talked briefly that another item we might consider is that there is no due process when a state's attorney makes public or in the process of a case has to have a Brady letter or a Giglio letter that calls into question the credibility of law enforcement. So the Brady and Giglio letter kind of hangs out there. We have heard law enforcement in testimony sometimes talk about that as like a scarlet letter. It's a letter from a prosecutor that says their credibility in a specific case, or sometimes even more broadly, is called into question. Representative Lalonde and I, in the original H251, took a tack of trying to say, let's bring a review of the Brady letter into the Criminal Justice Council's purview. And we're going to take a little bit of feedback on that idea and see if this is something that we want to include in the work that we do here in the next couple of days, or if it's something we want to keep working on further with our public safety and law enforcement work, which I'm sure will continue to be on this week. So I wanted to invite Ben, if you're ready, to take the hot seat and walk us through an amendment that tries to do a little update to H251. And we'll hear from folks who have some feedback about that as well. Thanks so much, Ben, for your work on this.
All right. Thank you, Chair McCarthy. Okay, so for the record, Ben Overgrowski from the Office of Legislative Counsel. Before the committee is draft 1.1 of an amendment to H251 that attempts essentially to, as Chair McCarthy kind of set the stage for, is it no longer creates a Brady or Giglio letter that's issued by a prosecutor as a basis, but includes the same concepts in the language. And the reason why is because a Brady or Giglio letter is issued by a prosecutor. It's within their prosecutorial discretion. So rather than kind of mixing the jurisdiction of a prosecutor and that of the Criminal Justice Council, the concepts that underlie the issuance of a Brady letter are now included in this amendment so as to create that distinction and separation of authorities. So if you first look at the changes, the first one is on page 2, lines 13 and 14. So what this does, this defines category B conduct, which is gross professional misconduct amounting to actions on duty or under authority of the state or both that involve the willful failure to comply with a state required policy or substantial deviation from a policy of a law enforcement agency, or if not defined, one that is defined by council policy. And the addition here, which is if it's not defined by council policy, then it's listed under this subdivision, which if you turn to page 3, lines 5 through 7, now includes the language of bias, untruthfulness, or failing to disclose other potentially exculpatory or impeachment evidence subject to disclosure in a criminal proceeding that undermines the police officer's credibility. And the reason why that additional lead-in language was added was that rather than going through the process of mandating the Criminal Justice Council to create a whole new statewide policy, this is a way to sort of short circuit it. There's been much testimony from the Criminal Justice Council about their limitations, their resources, and this was, I believe, an attempt to give them an assist on that front.
Representative Hanger.
Thank you. I need to go back in time because did I hear you say that this is in lieu of the issuance of a Brady letter? This would happen?
So H-251 said if a Brady letter happens, that can be a trigger, that would be category B conduct and could be the something that the Criminal Justice Council could take action on. That was the idea, right? Is that we would add the Brady letter. That was the original underlying idea in the bill as introduced by me and Representative Lalonde.
To the duties of the Criminal Justice Council, yes.
And additionally, the rescindment of such letter could be the recourse that the council takes. But upon further discussion and research, that could create a constitutional issue with prosecutorial discretion. So rather than making it contingent on a Brady letter itself and either rescinding that letter or taking some other action, this provides the council the jurisdiction to potentially sanction an officer for the same conduct that underlies a Brady letter. So that would be something that impugns the officer's bias, truthfulness, or any other conduct that would have to be disclosed in a criminal proceeding.
So a Brady letter would not have to be issued, but what if there were one issued?
That would still provide the same basis for the conduct to be brought before the council because it includes the same underlying conduct.
The parallel, I would say, and the reason I'm bringing this up in the context while we're looking at other category B misconduct, there's kind of been a similar evolution of this proposal as what happened with our Domestic Violence Fatality Review Commission proposal. So that proposal was originally having a trigger be the final RFA. And the place we are ending up, where we had talked about, and I think we'll even on in the compromise proposal we're going to see this afternoon, is about the conduct. It's about giving the Criminal Justice Council the jurisdiction to respond to complaints that are about the conduct, not about the specific instance of the document, the issuance of the RFA or the issuance of a Brady or Giglio letter. It's about the underlying conduct.
And
Sorry. So how would those complaints, if they weren't in a Brady letter, come to the attention of the council? Would it have to be that an officer was arrested for doing a certain thing?
No, and that's not how any of this professional misconduct is brought today. Ben, do you want to talk a little bit about any of the complaints that are under B misconduct are brought?
So, I mean, right now, under category B conduct, these are all ones that really have either a state policy that dictate them. So for instance, if you look on the top of page 3, placing a person in a chokehold. So the way that could be brought is that anybody that is a witness to that could bring a complaint to the council about that conduct. So it could be a fellow police officer. It could also be a prosecutor. And so there are really, is anybody that provides a reasonable basis or has knowledge of it could provide the complaint essentially. And just to kind of take it a step back, I mean, really what this addition, an amendment is trying to get at is complaints that get to an officer's credibility. And what that is, and giving the council some sort of action basis to provide action to remedy any situations where an officer's credibility could be in question.
So to build on that, letter H on page 3, line 5, anybody could say anything, and the Criminal Justice Council would have to investigate it.
Well, so for instance, there's H, but you have to read it in conjunction with sub 5 just beneath it. So the definition of undermines kind of elevates it. So on the one hand, Rep. Hanko, you're correct that it's sort of a broad sweep in H, but 5 narrows that because undermines is defined as meaning the commission or omission. So you either have to do something affirmatively or not do something of any conduct or statement concerning a material fact. So a material fact is well established in our jurisprudence, but while I don't have the case law in front of me at the moment, it's basically something that's directly relevant to the case. And a material fact that is reasonably likely to affect the outcome of a criminal, civil, or administrative investigation or proceeding. So that really raises the bar, is that it's not just any willy-nilly allegation. It would have to be something that really could affect the outcome of the investigation or proceeding. And that would be within the purview of either the agency, because the way that this goes is that an agency does an internal investigation, or depending on the circumstance, the council. And so they would conduct their investigation theoretically with this as a backdrop. So essentially, if there was conduct about an officer's bias that didn't affect or reasonably likely to affect the outcome of a case, it wouldn't necessarily be actionable at that point, but it could be investigated.
So shouldn't undermines number 5 be somewhere else and not following that? I see the ellipses there, so there must be something.
Yeah, so this is the definition section of it, so it's all read in conjunction.
Thank you.
Yeah, Ben, it would help me to maybe give a scenario of an officer that might receive a Brady letter and then what that Brady letter would be used for currently.
I think in that situation, I would defer my colleague, Tim Leaders-Dumont at the State's Attorney's Office to really see how that plays out. But my cursory understanding is that a Brady letter is issued, and it can be issued for various things. It can be about an officer being untruthful on an affidavit. It could be something that's revealed during maybe the review of the evidence of the case that shows some sort of policing bias. And it's within the prosecutor's discretion to issue that letter really at any point during the investigation or prosecution, whenever that evidence comes to light. And that, I think, as Chair McCarthy said, it's sort of like a scarlet letter for the police officer. Once that letter is issued, it follows the police officer. And really, I think prosecutors, it's assigned to not use the officer as a witness in a criminal case. But I would defer to the prosecutors in the room to elaborate a little bit more of the machinations of that.
That helps to some point.
That might be a good segue. So Ben, if you want to stick around, maybe I can ask Mr. Leaders-Dumont to come take the witness chair unless there's anything else about the bill.
There is one additional portion in the bill. So if you look on page 4, just a small amendment to the language that's used at the bottom of the page, lines 19 and 20, just parenthetically referring to it as officer credibility being undermined. And then there is also the removal of the rescindment language because it's no longer necessary, as I explained before, about creating that divide between prosecutorial discretion and the council's jurisdiction.
And we'll go to you, Representative Hango, in a moment. I did want to say for the committee that I'm doing my best to try to create a bucket of things and remain keep all of the ideas that are on the table for us to consider in these waning days of before crossover. I want to just flag that I understand that it could be confusing that if we look at this additional thing, it has this reference of being an H on the list of category B conduct. So if we adopted only this thing, it would be the new H. But then we're also talking about in the Domestic Violence Fatality Review Commissions, a category B misconduct now, that if we only adopted that, that would be H. So I just want to flag for the committee that there are two completely separate new potential B conduct that in this, because it's by itself, it's H and that over there. So I don't want to get too hung up on the references. If we passed both things, Legislative Council and the clerk's office would help us resolve them if we pass them separately.
Yeah, over the summer, that's what we do in our statutory revision, is that we reconcile those really sort of form over substance issues.
For a second.
Thank you. So you read my mind. The conversations that occur outside of this room where you have the context of having the back and forth between the various parties who are advising you on these would be so helpful for me, maybe for everyone else, to know where all this is coming from, where it's headed, and how they all fit in together. In the context of this room in a half an hour, there's no way I can process that and understand it. So to me, this is all new material and very confusing.
So we will not be taking any action on this today. I'm merely putting this on the table as another thing that is in the same air. Since our policy jurisdiction is so vast, I'm trying to narrow in now that we've gotten a couple of our other bills behind us and out of this committee on all of the things that were on the table for us. And we won't necessarily move all of them in the next 24 or 48 hours, but I thought it was worth taking at least a dive into this, and I think we'll bring up Tim and he'll give you more of that context. For this specific issue, we've talked about when we were talking with law enforcement way back when we had sheriffs in, for instance, about Brady letters. That's been an ongoing, thread of the conversation that's happened outside of this room. Representative Lalonde and I specifically introduced 251 to put this idea on the table that maybe we could use the process that the Criminal Justice Council has to either confirm or maybe perhaps, at least in part, kind of resolve the questioning of the credibility of a law enforcement officer that a Brady letter creates. And so this was our attempt to do that. Yeah, Ben.
Another potential way to look at this too is that this provides due process in a way to law enforcement officers that might have these allegations. Currently, right now, the issuance of a Brady letter is purely within the discretion of a prosecutor, or even to rescind a letter. What this would do is that it's almost like a parallel track, as a way to think about it, is that the same conduct can be complained to either the department or to the agency or to the council. Then the investigation, and if there is a hearing on it, could occur. And that provides sort of a fuller process than currently exists just with the issuance of a Brady letter. However, while this doesn't necessarily affect what a prosecutor can or cannot do, if this were to go through the whole process before the council and it deemed that the allegation didn't have merit or didn't require a sanction, it may make it more difficult for a Brady letter to kind of hang out there on a prosecutor. But again, the prosecutor has a discretion one way or the other to issue or rescind such a letter. But that's another way to think about it, is this actually provides a fuller process to the officer if these allegations are levied against them.
So let's hear from state's attorneys. And if there's an appetite to continue this conversation further, we'll definitely hear from law enforcement and department. And so this is definitely not just second or third piece of this conversation, not the last.
Well, Tim Leaders Dumont, Department of State's attorneys and sheriffs, and a legislative attorney, and a lot of alphabet soup with the double H's and the B's, and I'm also a member of the Criminal Justice Council on behalf of the department. And so just to start off, the Criminal Justice Council has a subcommittee that does deal specifically with certification. And so that's the purview of where this sort of thing lives. And then the broader council votes on the ultimate actions. And so there's multiple subcommittees on the Criminal Justice Council. That's one of, it's an investigatory aspect of the council. And Chris Burkell and the Criminal Justice Council can demystify that. I just wanted to say, starting off, the amendment, our department approves deeply of the amended version H251. It gets exactly at all of the issues that we had pointed out in previously submitted written testimony just before town meeting week. And this is something, the demystification of Brady Giglio, I want to say it might feel like a kind of amorphous topic. It really can be reduced to the following. Brady Giglio is a duty between the government and the defendant. It has nothing to do with law enforcement certification. What happens is in that bubble, when you're doing that disclosure, and I'll use my friend Mr. Hooper here as an example, say Bob is being accused of something and he's sitting close to me, so that's why he got picked. And we find out that, and this is part of the demystification, we find out that nothing to do with law enforcement, but one of the eyewitnesses has a previous false information charge to a police officer. That's Brady Giglio material. I have to disclose that to Mr. Hooper and his attorney. Is that sometimes law enforcement has material that has to do with them, but material has everything to do with the disclosure between the government and the defendant, and nothing to do with law enforcement certification or decertification, other than the fact that sometimes that same conduct material might be really relevant to something that's happening with respect to their ability to be a law enforcement officer. And so what I just want to applaud Attorney Nowogrodzki, who's done an incredible job making that, I think about it as two circles intersecting, right in the middle there. That's where you're focusing right now. And that conduct that might be captured in a Brady letter is what the council could then look at. And then there's a process for that officer to have that sort of litigated as to their ability to do their job as a police officer. Whether you pass the law here or not, prosecutors are going to continue to issue and disclose. More important than issue is disclose Brady material and Giglio material. The reason you hear both is because there are two Supreme Court cases. They're together, just one doctrine. Brady had to do with exculpatory information. That has to do with guilt or innocence, has to do with sentencing as well. And Giglio has to do with impeachment, bias, and truthfulness. So together, they're all one doctrine now. And it would really take an amendment to the federal constitution and also federal law, and in some ways to really have prosecutors not have that authority. So even if my legislature passed this, there was no rescinding of those letters. A prosecutor could rescind them on their own, but the council could never rescind a letter, so to speak. But I also just want to pause for a second and talk about the hypothetical that you posed, Representative Higley. And do you mind repeating that again? I was taking a note on it. Do you mind repeating the hypothetical?
Well, just giving me an example, and you kind of just did. But then again, what that letter could be used for afterwards.
Thank you. So the issuance of a letter is not mandatory. The disclosure of the material is mandatory. And so the idea that these are public-facing letters is kind of an important part of our modern interpretation of Brady Giglio, but it's really important. And I can just use Marshall Paul here as an example. I have to disclose stuff to him as a defense attorney if he's representing a client that has to do with exculpatory or impeachment information. It doesn't have to be in a letter that's published on the front page of the newspaper, right? It's just I have to make sure his client is aware of the fact that there's certain information that they need to know under their constitutional due process. And so it's sort of interesting in the context of what you all have been discussing today. But I just want to emphasize the new version of the bill does a great job of making sure the apples, which is Brady Giglio, and the oranges here, which is certification of law enforcement officers, are not confusing each other. And so that it really is important to sort of, if you do move forward with this, if there's two H's or there's an H and an I, that whatever has to do with untruthfulness has been sussed out really well here. And I think that you have done that in this draft. And the last thing I'll mention is Colorado has done something similar where they reference what could be described as Brady Giglio topics in one of their certification, effectively a category B in Colorado. But it's that untruthfulness, it's that, bias, credibility stuff. And so it might be the triggering event when you issue a letter and you send that letter to the Criminal Justice Council if you're a prosecutor under Act 56. Hey, just so you know, this officer, we have known about an issue with this officer, right? It might trigger that Criminal Justice Council action. Doesn't have to be in the form of a letter. It could be a witness list. It could be a criminal background check. It doesn't have to be a letter. And so I want to take every opportunity in public to tell you, you can issue Brady Giglio letters. You don't have to. What's mandatory is the disclosure. Does anyone have any, I just want to say it's a confusing topic, but it doesn't have to be. And every Wednesday I'll be in the cafeteria doing Brady Giglio half hour if you want to have a coffee. Any questions? I really am in strong support of this bill as currently amended.
Question from the state's attorney's perspective. So I wanted to thank you. You raised some real concern about the H251 as introduced by myself and Representative Lalonde, and I appreciate your work with Ben to get us to a place where we've separated the two things, as you said.
I do have another question, and that is there a length of time that information can come forward after a trial or whatever that one of these Brady letters could be instituted?
It could happen at any time.
Anytime.
And in fact, there's a good example that I dealt with in some ways with a post-conviction relief case. So after a sentence had been imposed and someone was actually, had been serving a sentence, years later, there was a disclosure about bias that took place. And we stipulated to the dismissal of that case after it had been adjudicated because that bias was not known until years later. So that was Brady happening at all times. And it goes along with the discovery obligations that we all have as attorneys, particularly prosecutors. The discovery just means sending the defense everything that you have that relates to the case. That obligation happens from the very moment that there's a law enforcement file sent forward for prosecution. And in our opinion, it happens as long as the person is living, because that person could be experiencing the effects of the conviction even after they serve their time. And as we know from your other discussions about criminal justice reform, having their criminal record could be a really damaging part of someone's life. So the obligation continues.
Thank you.
And thank you, Mr. Chair. It's a topic, as Marshall knows, we talked about it over the summer with a study report, and it's a topic that's an important one, and demystifying it for not just you all, but for the people involved too. Law enforcement, prosecutors, defense attorneys, and the public is an important duty that our department takes seriously.
Thank you very much.
Thank you.
I think it's a real challenge for us to try to respond to the myriad kind of evolving and developing issues around, everything that's happening, nationally and in the state, and some specific cases here in regard to some of these law enforcement issues. And, we've heard just from so many people that once these letters are out there, they're just kind of out there. And when they bring the credibility, or the integrity of a law enforcement officer into question, and there's no process to explore any of the details or the underlying context, that's definitely it was a concern for me, Representative Lalonde, the public. So I wanted to at least have the committee take a little further look at this. I want to know from the committee if it makes sense to hear from some more perspectives on this.
And can I add just one thing in terms of that check? I think we totally appreciate that for the law enforcement officer, it hangs out there. And so one of the things that, I think this bill does is if the letter is happening and prosecutors have to err on the side of disclosure. So whether it's a letter or the disclosure of a witness list or screenshot of a tweet that an officer makes, right? As long as the disclosure happens, we've satisfied our duty under the Constitution. But in terms of the public facing aspect of it, I think that's the important thing that you all are grappling with. And I think we appreciate that if there's a criminal justice counsel process as to the underlying conduct, then that's good for the officer. They get due process. Some due process is better than no due process in our opinion on this. So I think that public facing stuff is important, and we appreciate that.
Thanks for being with us.
Thank you, Mr. Chair. Good to see you. Won't use it as a hypo anymore.
So where I am with this particular thing, as we are in our about to hit crossover time, is that I would like to keep working on this issue. I would like to hear from law enforcement perspectives about whether this is a reasonable way to try to resolve this issue. I think the conversations we've had around the Domestic Violence Fatality Review Commission language and the concerns around that will be resolved by the draft that we'll see on that this afternoon. But with this one, to Representative Hango's point, I think we do have more work to do on it. So I think it's an important thing to take up at some point, and I'm not sure it's ready for us to take any action on right before crossover. So I want to acknowledge that, but because we're talking about these things, I wanted to sort of put a stake and say we've made some progress on this issue. We need to hear from more people and do more work on it. But this thing isn't going away. So if the committee's okay with me saying, I want us to keep this in mind, we're definitely going to be coming back to this at some point in either later this session or this year, but I don't think we're ready to move any of this. And there's more process we need to do to make sure that this is really going to benefit law enforcement in the way I think it would. The point that Tim just made. Representative Hanger.
Thank you. I really appreciate that because I know early on I questioned why we have this here. And I'm reading our mission as a committee, and it's the administration of public safety. And we just heard that this has nothing to do with the certification of a law enforcement officer, which to me is part of the administration of public safety. So I'm not really sure how this fits with us, and I'm trying to learn all these new judiciary type concepts, which I never thought I would have to learn in this particular committee. So like, why you and why not Chair Lalonde? Like, why are we taking this up here?
Yeah, so I think what you may have heard in Tim's testimony or in Ben's comments is that the Brady letter itself doesn't have to do with certification, but the underlying conduct, if we so chose to work with the stakeholders and continue down this path, the underlying conduct, bias, untruthfulness that is disclosed in a Brady letter, that very much does go to, in Representative Lalonde, in my opinion, having put this bill on the table, that conduct that underlies some of those Brady letters, that definitely goes to the certification, the administration, and who gets to be a law enforcement officer. And so it's the conduct that we were trying to get at. And we were also trying to get at due process. Now, you're absolutely getting at a tension between, we're right up against the line of what's judiciary and what's Gov.Ops. You're absolutely right about that. We are right there, which is why I wouldn't move all the way with this particular piece without, being at least doing drive-throughs or putting this over into the judiciary. But this is about the administration of law enforcement. This is about certification, the conduct, and whether there would be a sanction by the Criminal Justice Council. If we took this up, this is definitely right in our wheelhouse, but it touches on, what's going on when a prosecutor has to disclose certain information in the course of a case. That's very much up in judiciary's wheelhouse. So the challenge here is those disclosures, that document, the Brady letter that says, we're calling into, this prosecutor says that this calls into question the integrity, the credibility of a law enforcement officer, well, then the question that sits here in Gov.Ops is, well, what does anybody do about that? And right now, there isn't really, the letter's just out there for attorneys and the courts to deal with, but that's upstairs in judiciary. Here, it's about, do we do anything about the certification? Do we do anything with the Criminal Justice Council with the oversight path that we have on that? So that's why I wanted to lay this on the table, start getting it out there, start getting people talking about it. I don't think we'll move this piece of this week, but I think it's gonna, these Brady letters are right now causing some consternation both amongst law enforcement professionals that we've heard from and in the public to say, I mean, geez, this law enforcement officer is out there investigating and testifying and is the affiant, has this letter from a prosecutor that says X, Y, and Z about them. I think there's got to be some kind of process to evaluate the information that's there. We don't have one right now. All right. 11:32. Check in with our assistant and see where we're at with.
No, I don't know.
So I think if we've decided, and it seems to me that it's prudent to pause on our H-251 discussion, I'd like to take a 10-ish minute break for the committee. And there's a couple of questions that have come up around maybe the inclusion of one more member in the the Cybersecurity Council bill. We were going to try to take that up with Attorney Wasserman at the right before we break for lunch. So let's take a 10-minute break and then try to resolve that issue and come back. It may be that we just adjourn until we come back after.
Real quickly on that.
Sure.
Are you debating pulling tomorrow's 8:30 then based on what we just said?
Well, I want to
pausing on that, or do you still want to hear? Are we still going to hear?
I do want to hear from Judge Stoney on the other elements.
Okay.
Potentially. So
I was just looking ahead and aside.
Yeah. So I may take our morning testimony off. I'll know that by early afternoon.
Okay.
But thank you for flagging that. We are going to continue to work on the other pieces of the Criminal Justice Council bill tomorrow.
Right.
All right. So we'll come back here at 11:45 unless we end up having to push the cybersecurity conversation further. But thank you all so much for the good work this morning. So